Mr. Chairman, you have an absolute right to remain silent. No inference or suggestion of guilt may be inferred from your invocation of that right to remain silent. However, if you do testify or take the stand, you will be treated like any other witness and subject to cross-examination. Mr. Chairman, the reason that that phrase is running through my mind is because I heard it for 16 years. It's being repeated in courtrooms all across this country today, but not for powerful people that work for government, just for everyday folks. Just for everyday witnesses or everyday defendants of petty crimes, not charged with violation of constitutional rights, maybe just petty larceny. But they're being told you have a right to remain silent. However, if you testify or take the stand, you will be treated like every other witness. Mr. Chairman, I counted 17 separate factual assertions by Ms. Lerner, not those 3 little sentences that my colleagues like to cite, 17 separate factual assertions. That is a lot of talking for somebody who wants to remain silent. That's a lot of talking. If you honestly believe that you can make 17 separate factual assertions and still invoke your right to remain silent, then please tell me what waiver is. Please tell me what constitutes waiver if saying 17 separate factual things does not. Mr. Chairman, she testified, I have done nothing wrong, I've broken no laws, I've broken no IRS rules or regulations. That's her testimony. What I'm saying is we should have the right to cross-examine her on that testimony. Because I'd like to ask her, when you said we need a plan, who is we and what plan are you referring to? When she said we need to be careful that it's not perceived as political, who is we and what are you concerned about the perception of politics for? What are you fearful of, Ms. Lerner? She said, I think we really need to do a project. Again, Ms. Lerner, who is we and what project are you referring to? That is a legitimate question. And every brother and sister at the bar on the other side of the aisle would ask that question on cross-examination if given the opportunity. Can you imagine, Mr. Chairman, can you imagine a fact pattern where somebody takes the stand and says, I didn't rob the bank, but I'm not going to answer why my fingerprints are on the demand note, and I'm not going to tell you why I'm on the surveillance footage with the gun in my hand, and I'm not going to tell you why the dye pack blew up in my car. I'm just going to tell you I didn't rob the bank. That's not the way our system works. You have to answer the other side's questions. I think these questions are fair. The Tea Party's very dangerous. Dangerous to whom? Who, Ms. Lerner? Who thinks they're dangerous? You? The IRS? Dangerous in what way? We need a vehicle to get back to court. Who is we? Why do you want to get back to court? Could it, heaven forbid, be because you don't like Citizens United? Is that possibly the explanation? Mr. Chairman, she said Cincinnati should not have these cases, but then she turned around and said Cincinnati was to blame. That's an inconsistent statement. Every lawyer on that side of the aisle would ask her to explain that inconsistency. Everyone. So why can't we? If this isn't waiver, then can someone explain to me on the other side what fact pattern constitutes waiver? If you can make 17 separate factual assertions and authenticate a document, and say, I have done nothing wrong, which is about as broad as any testimony can possibly get. I've done nothing wrong. I've broken no laws. I've broken no rules or regulations. I mean, honestly, what testimony could be broader than that? So necessarily, our cross-examination should be equally broad, and it would be in a courtroom. Can the president suspend election laws?
No.
Why not? If he can suspend mandatory minimum and immigration laws, why not election laws?
Because we live in a government of laws, and the president is bound to obey them and apply them.
Well, he's not applying the ACA, and he's not applying immigration laws, and he's not applying marijuana laws, and he's not applying mandatory minimums. What's the difference with election laws?
We have a disagreement as to whether, in fact, he is applying those laws.
Did
My
he?
view is that he is applying those laws.
Did Eric Holder instruct his prosecutors to no longer follow the mandatory minimums with respect to charging decisions?
Now, this is an area where I really don't know nearly as much as you do, Congressman.
I'd find that shocking that anybody would not know more than I do on any topic. Who would you like me? You want me to ask Professor Turley?
That my impression is that he's not exactly doing what you've just said.
Well, tell me how I'm wrong, because Eric Holder sent out a memo that we are no longer going to put in the indictment the drug amounts. Do you agree with me that Congress can pass mandatory minimums?
Constitutionally, yes.
Do you agree that Congress can pass statutory maximums?
Pardon me?
Can Congress also pass statutory maximums? In other words, you can't get more than 30 years for a crime.
Of course.
Can a president exceed a statutory maximum?
Can he extinguish, did you say?
No, can he exceed it?
Can he exceed it? Well, how would he do that? I mean, keep someone in prison beyond his prison term.
Well, if you can put them in prison for less time than Congress says is the law, can you also do it for more time than Congress says is the law?
It's really, it's not.
I think all of the witnesses have made reference to 11 million. I hear it everywhere I go as if it's a homogeneous group, and we know it's not. And you made reference several times to the 11 million. Would you agree with me that those members of the 11 million who can't pass a background check shouldn't be on a path to anything other than deportation?
Maybe the people that don't pass a background check, but I do believe that there should be a pathway for the majority of the 11 million.
Well, now that's a very different from what you said earlier, and that's kind of my point. My point is all 11 million can't pass any background check. All 11 million of any category of people, from preachers to members of Congress, can't pass a background check. Mm-hmm. So why persist with the talking point of 11 million when we know that that's disingenuous? All 11 million don't want to be citizens. All 11 million can't pass a background check. Mm-hmm. And even if you concede that, then we get to the details of what the background check is going to look like. For instance, if you were sitting where Mr. Amade is sitting, if you have a conviction for domestic violence, should you be on a path to citizenship or a path to deportation?
Well, I can only argue for my sake and my parents' sake.
No. With all due respect, you advocated on behalf of 11 million aspiring Americans. You're not a difficult fact pattern. Ms. Rivera is not a difficult fact pattern. So the talking point of 11 million aspiring Americans, I'm not interested in that. I'm down in the details of what does a background check look like. Do you think a conviction for domestic violence should disqualify someone from being on a path to citizenship or status?
I think I'm going back again to that's up to you all to decide.
Well, if it's up to us, then why do I constantly hear 11 million if it's one monolithic, homogeneous group? Why? I mean, why not just say what you said? There are subgroups that warrant different levels of scrutiny. For instance, children who were brought here with no criminal intent, that warrants one level of scrutiny. The parents who brought them here who can fashion criminal intent warrants another level of scrutiny. Those who have misdemeanor convictions have one level of scrutiny. Well, those who have multiple misdemeanor convictions have a different level of scrutiny. Those who have felony convictions have a different level of scrutiny. Why is that not the more honest response than to talk about 11 million aspiring Americans?
Well, honestly, I'm in no position to tell you who deserves what, and I don't know what you would do. How would you decide that one person deserves something that the other doesn't? So,
well, it's not hard for me. I spent 16 years prosecuting people for domestic violence. That's a disqualifier to me, even though most states consider it a misdemeanor. So with all due respect, the devil is in the details.
Right.
The Department of Justice, Mr. Chairman, is not just another agency within the federal government. The Department of Justice is responsible for safeguarding the fundamental foundation of this republic, which is respect for the rule of law. The department is symbolized, Mr. Chairman, by nothing more than a blindfolded woman holding a set of scales and a sword. She doesn't care about political agendas. She doesn't care about whether her decisions help or hurt people's reelection bids. She doesn't care about race, gender, socioeconomic status, just the equal application of the law so all citizens can have confidence in the decisions that she makes. So it is against that backdrop, Mr. Chairman, that we look at the facts surrounding this investigation. Fast and Furious was fundamentally flawed in its conception, flawed in its execution, and flawed in its explanation afterward. And this is not, Mr. Chairman, as was initially the administration mantra, an Arizona investigation. Senior level officials within the Department of Justice in Washington knew about Fast and Furious well before Special Agent Brian Terry was murdered. Senior level DOJ officials were briefed. They discussed press conference opportunities. They discussed the unsealing of indictments. They traded emails about the status of the case. They approved wiretap applications, and most significantly, Mr. Chairman, they actively discussed the tactic of gun walking well in advance of Special Agent Brian Terry's murder and well in advance of a demonstrably false letter being written to a committee of Congress that was calculated to deceive and mislead. And here's the proof. Here, Mr. Chairman, is the proof that Department of Justice in Washington, not Arizona, in Washington, knew about the tactic of gun walking well before Brian Terry was murdered. So we have a fundamentally flawed federal investigation. We have a dead Border Patrol agent. We have hundreds of dead Mexican citizens, thousands of weapons with America's fingerprints on both sides of the border unaccounted for, and a demonstrably false letter being written to a committee of Congress, and yet we're being asked for more time. Please wait. Give it more time. It's been over a year, Mr. Chairman. If Congress has time to look into Major League Baseball, the BCS, and invite Stephen Colbert to come to a committee hearing, surely to goodness we have time to get answers on a fundamentally flawed, lethal investigation like Fast and Furious. And thus we have, Mr. Chairman. We embarked on an investigation to get answers to some pretty fundamental questions that I still cannot answer. When I'm asked back in South Carolina, who within Maine Justice approved this investigation, I can't give them an answer. When I'm asked who knew about gun walking and did nothing to stop it, I can give them this, but this is part of the answer because it's part of the documents. How did the demonstrably false letter get written on Department of Justice letterhead and delivered to a United States senator? I can't tell you how that letter got drafted. Why was it withdrawn after 10 months? Why did it take 10 months to withdraw the letter? Why was the criminal chief, to my friend Pat Meehan's point, why was the criminal chief of the Department of Justice in Mexico advocating for gun walking on exactly the same day that this demonstrably false letter was delivered to a committee of Congress? Can anyone answer that question? Can you tell me why Lanny Brewer was in Mexico advocating for a tactic that we all acknowledge is flawed on the very same day the Department of Justice was denying the tactic to Senator Chuck Grassley? Not only does Congress have a right to ask these questions, we have a fundamental duty to ask these questions. Our fellow citizens, the ones we're supposed to work for, when they get a jury summons, do you think they have a choice on whether or not to comply? When they get a subpoena from a law enforcement agency, do you think our fellow citizens get to offer an extraordinary accommodation in lieu of providing the documents? Either Congress has the authority to send a subpoena and require full compliance, or what we have been doing for the past 12 months is a fool's errand.
Mr. Schulman, when you learned that conservative groups were being targeted by the IRS for discriminatory treatment, what did you do?
When I learned of the existence of a BOLO list, in that same conversation or right around that time, I also learned a couple things. One, that it was being stopped. So that,
all right, and who told you it was being stopped?
That's Steve Miller, my deputy.
All right. And did you investigate further? Can you give me the name of a single person who was involved in the original decision to target conservative groups for disparate treatment?
I'm not aware of those names.
Why can't you give me a name?
So at the same time that I learned and that it was being stopped, I was also told that the Inspector General was aware of it.
Mr. Schulman, is the Inspector General the only person who can investigate wrongdoing within the IRS?
My general practice.
Can you answer my question, and then you can explain? Is the Inspector General the only entity who can investigate wrongdoing?
Congress can investigate.
How about you? Can you do it?
The practice at the Internal Revenue Service that I inherited.
So if there's inappropriate conduct being done on your watch in the IRS, then that inappropriate conduct can last as long as the Inspector General's investigation lasts. Is that what you're telling me? That you're not going to step in and stop it?
No, what I'm telling you.
If there's someone wielding a knife in the parking lot, are you going to call the Inspector General? Are you going to wait until his or her investigation's over before you stop it?
When I was told about these allegations, I was also told that they were being stopped, and so that the inappropriate criteria were not being used
anymore. And despite the seriousness and potential criminality of that conduct, you didn't investigate it yourself at all?
So the procedures that I inherited and that my
Mr.
general
Schulman,
practice
this is going to go much quicker if you'll answer yes or no, and then you can explain. Did you do anything to verify that the practice, as insidious as it was stopped?
The Inspector General was going to be looking into it, and that's what.
Is it that you can't say yes or no, or you're just choosing not to say yes or no? Can you answer the question, did you do anything personally to make sure that this insidious, discriminatory practice was stopped? Yes or no?
At the time that I learned about it, I also learned two things. The first was that it was being stopped, and the second was that the Inspector
General. And what did you do to verify that it was stopped?
The responsible deputy of the Internal Revenue Service told me it was being stopped. I had no reason to believe otherwise.
Did you investigate why conservative groups were being targeted?
Excuse me?
Did you investigate? So you can't give me a single name. You can't answer the who. Can you tell me the why? Why were conservative groups? Why was the culture such under your watch that an employee felt comfortable targeting conservative groups? Did you investigate that?
You know, from my reading of the report, I can't tell if it was political motivation or if it was tone deaf, somebody trying to expedite a way to
You still don't know that this was political.
Excuse me?
You still don't know that this was political?
I'd defer to the Inspector General.
Well, I'll tell you this, Mr. Schulman. Your predecessor said that he wasn't sure if it was partisan, and that requires the listener to be as stupid as the speaker. We will not waver in our commitment to see that justice is done for this terrible act in Benghazi. And make no mistake, justice will be done. That was the President of the United States over a year ago. We're investigating exactly what happened, but my biggest priority now is bringing those folks to justice. That was the President of the United States over a year ago. No one has been arrested. No one has been prosecuted. No one has been brought to justice. We don't even have access to the witnesses. You and the media were good enough for my 16 years as a prosecutor not to tell me how to do my job. And so far in Congress, y'all have been good enough not to tell me how to do my job. I'm not telling you how to do your job. But I'm going to ask you some questions, and if you can't answer these questions, then I'll leave you to draw whatever conclusion you want to draw about whether or not the media has provided sufficient oversight. Can you tell me why Chris Stevens was in Benghazi the night that he was killed? Do you know? Does it bother you whether or not you know why Chris Stevens was in Benghazi? Do you know why we were the last flag flying in Benghazi after the British had left and the Red Cross had been bombed? Do you know why requests for additional security were denied? Do you know why an ambassador asking for more security days and weeks before he was murdered and those requests went unheeded? Do you know the answer to why those requests went unheeded? Do you know why no assets were deployed during the siege? And I've heard the explanation, which defies logic, frankly, that we couldn't have gotten there in time, but you know they didn't know when it was going to end. So how can you possibly cite that as an excuse? Do you know whether the president called any of our allies and said, can you help? We have men under attack. Can you answer that? Do any of you know why Susan Rice was picked? The Secretary of State did not go. She says she doesn't like Sunday talk shows. That's the only media venue she does not like, if that's true. Why was Susan Rice on the 5 Sunday talk shows? Do you know the origin of this mythology that it was spawned as a spontaneous reaction to a video? Do you know where that started? Do you know how we got from no evidence of that to that being the official position of the administration? In conclusion, Congress is supposed to provide oversight. The voters are supposed to provide oversight. And you were supposed to provide oversight. That's why you have special liberties, and that's why you have special protections. I am not surprised that the President of the United States called this a phony scandal. I'm not surprised that Secretary Clinton asked, what difference does it make? I'm not even surprised that Jay Carney said Benghazi happened a long time ago. I'm just surprised at how many people bought it.
And in that light, Ms. Eckelbrett, did you hear the president say there was not a smidgen of corruption?
I've heard that he said that, yes, sir.
Ms. Garrison, did you hear the president say there was not a smidgen of corruption? And let me just translate that, because smidgen's not a legal term. I assume he meant scintilla, and I assume he meant criminality instead of corruption. How was he able to make that conclusion? Neither of you have been interviewed by the Bureau, have you?
No, sir.
And according to Mr. Sekulow, of his 41 clients, 3 have been interviewed, or 3 were asked to be interviewed.
Right. Not interviewed yet.
Okay. 0 of 41 have actually been interviewed.
Correct.
All right. So the president says there's not a smidgen of criminality or corruption. Do either of you remember seeing a witness named Lois Lerner sitting at the very table y'all are sitting at? Do you remember her invoking her Fifth Amendment privilege, the same privilege that she targeted some of your groups for trying to educate people about? Some of your groups just want to simply educate people about the Constitution, the one that she availed herself of the very second she was exposed to criminal investigation. So how can the president say there's not a smidgen of criminality when Lois Lerner invoked the Fifth Amendment? 41 witnesses haven't been interviewed, including the 2 that are here right now. How can he possibly draw that conclusion?
Good question.
I wish one of the colleagues on the other side of the aisle would ask the president how in the world he concluded no criminality when Lois Lerner sat in front of them and invoked her privilege against criminality. How do you square that?
Mr. Gowdy, if I may, she invoked her Fifth Amendment privilege, which she has the right to do, of course. You and I both respect that because we now know the reason why. It wasn't perhaps as clear as it was made yesterday. She invoked her Fifth Amendment privilege because she knew, after she made a false statement and a planted question at an ABA meeting, she knew that, in fact, there was her words and her emails, off-plan drafting of rules targeting conservative groups. She also said at a Duke Law Forum that people are asking us what we can do, and she said, I can't do anything until I see the 990s, the tax returns that are filed. That was all going on while she was redrafting the rules with the highest level of the Chief Counsel's office. Mr. Cartwright.
Mr. Sekulow, yes, I want to say this.
I understand why she invoked her Fifth Amendment privilege. I don't understand why in the hell the President of the United States would prejudge an investigation
I don't either.
before any of your clients were interviewed, before either of these two victims, and I know you don't like that word, but I'm using it in the criminal sense of the word, before either of these two victims were interviewed. He has gone on national television. He has prejudged the investigation, and in my judgment has compromised the Department of Justice, which leads me to this question, Mr. Sekulow.
Yes, sir.
There is the option, when you have a compromised investigation and a chief executive who has prejudged the outcome before the jury's even gotten all the evidence, he's got an option of appointing a special counsel, right?
Yes, he does.
And the special counsel regulation says if it's extraordinary circumstances that furthers the public interest. Can you think of anything more extraordinary than government targeting people based on their political beliefs?
No.
Mr. Hicks, let's find out the truth. The president of Libya responded to the attack and labeled it an attack by Islamic extremists, possibly with terror links, correct?
Yes, sir.
So hours after our ambassador and 3 others are killed in Benghazi, the president of Libya says it was an attack with possible terror links, correct?
Yes, sir. That's what I recall.
Did the president of Libya ever mention a spontaneous protest related to a video?
No, sir.
When Ambassador Stevens talked to you, perhaps minutes before he died, as a dying declaration, what precisely did he say to you?
He said, Greg, we're under attack.
Would a highly decorated career diplomat have told you or Washington had there been a demonstration outside his facility that day?
Yes, sir, he would have.
Did he mention one word about a protest or a demonstration?
No, sir, he did not.
So fast forward, Mr. Hicks, to the Sunday talk shows and Ambassador Susan Rice. She blamed this attack on a video. In fact, she did it 5 different times. What was your reaction to that?
I was stunned. My jaw dropped, and I was embarrassed.
Did she talk to you before she went on the 5 Sunday talk shows?
No, sir.
You were the highest-ranking official in Libya at the time, correct?
Yes, sir.
And she did not bother to have a conversation with you before she went on national television?
No, sir.
Mr. Hicks, I want to know 2 things. Number one, why in the world would Susan Rice go on 5 Sunday talk shows and perpetuate a demonstrably false narrative? And secondarily, what impact did it have on the ground in Benghazi, the fact that she contradicted the president of Libya?
As to the first question, I cannot provide an answer, but perhaps you should ask Ambassador Rice.
I would love the opportunity to do just that.
As to the second question, at the time we were trying to get the FBI to Benghazi to begin its investigation. And afterwards, we encountered bureaucratic resistance for a long period from the Libyans.
For almost a year, there was an escalating pattern of violence directed towards the United States and other Western targets in Libya. Attacks on the consulate in Benghazi, attacks and assassination attempts on the British ambassador, attacks on the International Red Cross, attacks on courthouses, judges assassinated, culminating on September the 11th in the murder of 4 Americans, including our ambassador to Libya. Before those 4 murders, Mr. Chairman, just a few weeks before that, our embassy in Libya said this to the Department of State: the security condition in Libya remains unpredictable, volatile, and violent. So, Mr. Chairman, despite what would appear to any reasonably objective observer as an escalating pattern of violence, including sophistication, coordination, and management, this administration blamed the murder of our ambassador and 3 others on a video. Don't take my word for it, Mr. Chairman. Let's look at what Ambassador Rice herself said. Our current assessment is that what happened in Benghazi was, quote, in fact, initially a spontaneous reaction. I don't know what the phrase in fact means in diplomatic legalese. I can tell you what it means in a courtroom, Mr. Chairman. It means it's a fact. And she went on national television and she said, not as this ambassador has said, that I'm not going to speculate, that I've got to get all the information. She said, in fact, this was a spontaneous reaction to what had just transpired hours before in Cairo, almost a copycat of the demonstrations against our facility in Cairo, which were prompted, of course, Mr. Chairman, by a video, is what she said. And then she proceeds to say the attack was spontaneous. I can think of few things, Mr. Chairman, more antithetical to spontaneity than a 12-month-long prologue of violence in Libya. And then she said she relied solely and squarely on the information the intelligence community provided. Mr. Chairman, I would like to have another hearing where we can ask Ambassador Rice under oath, who told you what when? You're going to blame the intelligence committee? You come before this committee and you tell us who told you it was a video. Who in the intelligence community said it? Who in the diplomatic community blamed this on a video? And then we move to Jay Carney, who's the spokesperson for the leader of the free world. This is what he said, Mr. Chairman. I'm saying based on information that our initial information that includes all information, we saw no evidence to back up claims by others that this was a pre-planned or premeditated attack. What we saw was evidence that it was sparked by the reaction to this video. And that is what we know thus far based on evidence, concrete evidence, close quote. Mr. Chairman, you know that in a former life, I spent a little time in the courtroom. So when I hear the phrase concrete evidence, it means something to me. That's even stronger language than simply saying something is in fact. So 2 representatives of this administration gave demonstrably false statements, not just to us, but to our fellow citizens on national television. Now, is the explanation for those demonstrably false statements, as my colleague from Florida just asked, was it negligence? Was it just a reckless disregard for the truth? Or was it more nefarious than that? Mr. Speaker, I want to have a pop quiz. That may seem unfair to my colleagues on the other side of the aisle, but I'm going to give them a hint. The answer to every one of the questions is the same. I'm going to read a quote, and then you tell me who said it. These last few years, we've seen an unacceptable abuse of power, having a president whose priority is expanding his own power. Any guess on who said that, Mr. Speaker? It was Senator Barack Obama. Here's another one. No law can give Congress a backbone if it refuses to stand up as a co-equal branch. The Constitution made it. Senator Barack Obama. What do we do with a president who can basically change what Congress passed by attaching a letter saying, I don't agree with this part or that part? Senator Barack Obama. I taught the Constitution for 10 years. I believe in the Constitution. Senator Barack Obama. And my favorite, Mr. Speaker, one of the most important jobs of the Supreme Court is to guard against the encroachment of the executive branch on the power of the other branches. And I think the Chief Justice has been a little too willing and eager to give the President more power than I think the Congress or the Constitution originally intended. So my question, Mr. Speaker, is how in the world can you get before the Supreme Court if you don't have standing? What did the President mean by that when he looked to the Supreme Court to rein in executive overreach? If you don't have standing, how can you possibly get before the Supreme Court? So my question, Mr. Speaker, is what's changed? How does going from being a senator
to a president rewrite the Constitution. Mr. Jarvis, in October of 2011, Occupy protesters descended upon McPherson Square and they decided to stay. Despite the clear language of the law, these protesters camped at McPherson Square with the definition of camping being sleeping or preparing to sleep for 100 days. They camped in violation of the law, and you did not make a single solitary arrest for camping. So Congress decided to have a hearing and ask you why you were not enforcing the law. And you told us, Mr. Jarvis, that you had a great deal of discretion in how and when to enforce the law. You told us that you were, after 100 days of not enforcing the plain language of the statute, working with protesters to, quote, gain compliance, whatever the hell that means, with the law, and what you called, quote, a measured and reasoned approach. By the way, Mr. Jarvis, those were your words, not mine. So the law says no camping, but the protesters camped anyway, and you didn't do anything in terms of arrest or citations for over 100 days. So, Mr. Jarvis, I want you to fast forward 2 years. Parks are closing, access to monuments is restricted, even access for those who helped build the monument in the first place. You didn't wait 100 days to enforce the law, Mr. Jarvis, with veterans who wanted to see their monument. You didn't work to gain compliance. Veterans weren't greeted with a measured and reasoned response, Mr. Jarvis. They were greeted with barricades on the very first day. Furthermore, they could not exercise their First Amendment rights to walk to a monument that they helped build, but yet some of our colleagues were allowed to exercise their First Amendment right to protest whatever it was they were protesting on the National Mall. So I'm going to read something to you, Mr. Jarvis. And I want you to ask me if you recognize who said this. Because of the lapse in funding, you are having to deliver difficult news to our visitors and partners. The functions we must perform under a shutdown are not the reasons any of us join the National Park Service, but they are the duties we are required to perform by law and regulation. Do you know who said that, Mr. Jarvis?
I believe I said that.
You're right, you did. So can you tell me why you would not enforce the law at McPherson Square, but yet you greeted veterans with barricades on the very first day? What regulation can you cite to me that required you by law to erect barricades?
The contingency plan that was approved on September 27th for the National Park System is in compliance with the Anti-Deficiency Act.
I'm looking for a statute, Mr. Jarvis. I am looking for a citation to the Code of Federal Regulation or the U.S. Code for why you erected barricades. We've established you did not enforce the law for 100 days for protesters. Agreed? You agree with me? You did not issue a single citation for camping, right?
I believe that is correct.
Either it is or it didn't. Is it? Not one single citation for camping.
I do not remember exactly.
Well, your previous testimony was that you had not issued a single citation for camping despite 100 days of noncompliance.
That was 2 years ago.
Okay. Well, I can cite you the regulation that you did not follow 2 years ago. Can you cite me the regulation that required you to erect barricades to prevent veterans from accessing a monument that they built?
I can cite the Anti-Deficiency Act.
Can you cite a regulation that required you to erect barricades? Mr. Jarvis, that is not a complex question.
The Anti-Deficiency Act requires that I reduce all employees down to only those that are necessary for life and property. That required the closure of all 401 national parks.
Mr. Jarvis, why did you fail to enforce the plain language of a statute for 100 days for protesters? And yet, on the very first day, you denied access to a monument that veterans helped build.
On the very first day of the closure, I implemented a closure order for all 401 national parks in compliance with the Anti-Deficiency Act. And immediately that day, also included as a part of that order that First Amendment activities would be permitted on the National Mall.
Do you consider it First Amendment activity to walk to a monument that you helped build? Or is it only just smoking pot at McPherson Square? Commissioner, Lois Lerner sat where you're sitting right now and said, I have broken no laws, I have done nothing wrong, and I have violated no IRS rules or regulations. Now, as a very highly accomplished attorney like yourself, you would have to concede that's pretty broad testimony, wouldn't you?
That's a statement, whether it's broad testimony and what its relationship is to the...
No, it's broad. Your scope of cross-examination, if we'd been in trial, would have been unlimited. You mentioned a judge earlier, what a judge would do with this subpoena. Let me tell you what a judge would do with that testimony. You could ask just about whatever you wanted to ask. When a witness says, I've done nothing wrong, that is tantamount to saying, I've done everything right. I can't think of any testimony broader than that. So necessarily, our line of inquiry would also want to be broad. Wouldn't you agree?
I think your line of inquiry ought to be what it is, no matter what people have...
Well, no, you said a judge would throw our subpoena out, and I can't help but note you haven't moved to quash our subpoena, but you think a judge would throw our subpoena out as being overly broad.
If we were in the private sector, which we're not, the judge...
Well, I want to make it easier for you. How long will it take you to produce Lois Lerner's emails that don't involve 6103 material from January of 2010?
Well,
could we have that by Friday?
Absolutely not.
Why?
No way, because there's no way physically we can get
January of 2010. That's 1 month, no 6103 material, just email.
1 month.
Just 1 month. When can we get that?
Well, we have to go through each of those emails to make sure it has no 6103.
Well, how long is that going to take? Can we have it by Friday?
I have no idea.
Just 1 month, Commissioner. January of 2010. No 6103, and let me tell you why I'm interested in it.
No, well, I'll tell you, today is Wednesday. I'd be happy to ask the people who do the work and get back to you.
All right, let's do January of 2010, and then let's get ambitious and do February of 2010, and then let's go March 2010. And I think you know why I'm doing 2010, Commissioner. When the President likes 5-4 Supreme Court decisions, he calls that settled law, like the ACA. When he doesn't like 5-4 Supreme Court decisions like Citizens United, he attacks it, which is what he did in January of 2010. And that's why the timeline is so important, Commissioner. The jury is never entitled to know the motive, but they always want to know the motive. You don't ever have to prove why somebody did something, but the jury always wants to know, why did this happen? And if you start in January 2010 with the President's State of the Union address, and then you move through Lois Lerner's emails that have nothing to do with 6103 material, you begin to see a motive develop.
Great. You're going to get 20,000 pages of documents this afternoon. Some of them may well be January 2010. But I will check with our people, because if you would like us to stop that production of Lois Lerner emails and go to January 2010, I will go and find out exactly how long.
What I want is this. I want the subpoena complied with. I want it complied with in a timely fashion. And you and I both know that if there's no 6103 material, whether or not you think we need something or we ought to have it, or that we're on a wild goose chase, frankly, I could care less what you think about that. I have been fascinated by, and not necessarily in a good way, by the evolution of the defense in this case. Mr. Chairman, initially it started when Lois Lerner disclosed this information in a fashion most calculated to be ignored, with a planted question at some boring conference. And then the second iteration of this defense was blaming 2 rogue agents in the Ohio field office. And Mr. Chairman, make no mistake, Jay Carney advanced and furthered that narrative, and he did so intentionally. You know, Mr. Carney's willingness to say, I don't know, is exceeded perhaps only by his willingness to acknowledge that he appreciates the question. But he didn't say, I don't know. he advanced the narrative that 2 rogue agents were responsible for this insidious discriminatory practice. And then we had colleagues that said this matter was closed. Months ago, Mr. Chairman, the matter was closed. And then the new iteration of the defense says, well, at least the White House isn't directly involved, as if that's the new standard for propriety in this town, that at least the White House directly didn't know about it. So that's our defense. And then the defense, Mr. Chairman, morphed into this, the most novel of all defenses, that the IRS is too poorly managed to be capable of concocting a scheme this sophisticated. That was the defense, that my client's too dumb to have committed this crime. And then, Mr. Chairman, we moved to the most recent defense, which is that, no, we didn't just improperly target conservative groups, we improperly targeted all groups. So while we may be guilty of improper conduct, we're not guilty of discrimination, because we did it against people at both ends of the political spectrum. So that's our defense. And now to see the Inspector General attacked. Mr. Chairman, there was an axiom in court that if you had the facts, pound the facts. If you had the law, pound the law. If you didn't have either one, pound the judge. And what's been said about Mr. George is reprehensible, and I can't wait till he has an opportunity to defend himself. But let me tell you what else is reprehensible, Mr. Chairman. Lois Lerner sat where those 2 witnesses sit today, several weeks ago. And these 2 witnesses put on a uniform and fought and defended this country and the Constitution so she could hide behind the Constitution and invoke her Fifth Amendment right, but only after she blamed them. She blamed 2 rogue agents in Ohio, and then didn't have the courage that these witnesses. I ought to just be thankful anytime IRS agents don't invoke the Fifth Amendment. I ought to be glad that anyone's willing to come before a committee of Congress and testify. Was Secretary Clinton aware of the attacks on Western targets in Benghazi leading up to September 11, 2012?
I believe our information.
I'm asking Admiral Mullen.
Was, yeah.
I'm asking Admiral Mullen.
I think she was.
She was aware of the attacks on Western targets. Was she aware that the British ambassador was almost assassinated in Benghazi in the weeks and months leading up to September 11, 2012?
I mean, I can't be positive, but I think she was.
Was she aware of the request for additional security at the Benghazi facility?
I would say no.
Was she aware of a specific request from the ambassador himself for improved security at that facility?
We never saw any request from Ambassador Stevens to.
That wasn't my question. Was she aware of it?
We never saw anything that indicated Ambassador Stevens asked for a significant upgrade at the facility.
Well, there's been testimony that he has. My question was she aware of that? Was the Secretary of State aware of it?
I don't know the answer to that.
All right. And here's what I found confounding about that. The 1998 ARB, you start your ARB with a quote from a Spanish-American philosopher about history, and those who don't study it are doomed to repeat it. Yeah. And I found that interesting because the 1998 ARB recommended this: the Secretary of State should personally review the security of embassies and other official premises, closing those which are highly vulnerable and threatened. The Secretary of State. That was the specific recommendation from history. So you can understand, with all due respect to my colleagues who don't want to mention the Secretary of State's name, you can understand my question: did she personally review the security at Benghazi?
I don't know that. Not all the evidence that we saw indicated no, but I don't know the answer to that.
Did she personally consider closing the facility in Benghazi? Again, given the fact that a panel exactly like the one you co-chaired recommended the Secretary of State personally review it. My question to you is, did she?
I'm not aware that she did.
So there is no evidence, despite a previous recommendation from an ARB just like yours, because what our colleagues on the other side say is, let's don't study the past, let's just look forward. You've made recommendations, all's going to be well now, all 30 of them will be implemented. And my point is, we had this recommendation. We had it in 1998, that the Secretary of State herself review the facilities and consider closing them if they are not safe.
I think one of the, and I think we have pulled people out where it wasn't safe over the course of that year.
But my question, Admiral, is you never interviewed the Secretary of State about whether she accepted and performed a responsibility given to her by a previous accountability review board. Mr. Holder, it is provable beyond a reasonable doubt, in my judgment, that Maine Justice had actual or constructive knowledge of gun walking, both in Fast and Furious and beforehand, and I'm going to prove it to you. March of 2010, DOJ, not U.S. Attorney's Office in Arizona, DOJ assigned a prosecutor to Fast and Furious. March 2010, Gary Grindler, who I believe is your Chief of Staff, knew about straw purchases and Fast and Furious and seizures in Mexico, and it doesn't take a very good prosecutor to ask how weapons got from Phoenix to Mexico. July 2010, a memo to you through the acting deputy AG. That memo specifically mentioned Fast and Furious. It specifically mentioned straw purchasers. It specifically mentioned 1,500 firearms supplied to Mexican drug dealers. That's July of 2010, 1,500 firearms. April 30th, 2010, a memo from Maine Justice employee Weinstein to Lanny Brewer. ATF let a bunch of guns walk. And then the rest of the email is worrying about the negative press connotations that may have come from that. Not how to fix the policy, but how to mitigate negative press consequences. October of 2010, Jason Weinstein and James Trusty swapped emails and specifically mentioned gun walking. And Mr. Attorney General, that email is so illustrative of our frustration with the notion that Maine Justice did not know about this. I'm assuming that James Trusty is a Maine Justice employee. Am I correct?
I believe that's correct.
All right. This is the email. And they're specifically talking about Fast and Furious. And in fairness, they also mentioned Laura's Tucson case. They say it's a tricky case given the number of guns that have walked. But it's a significant set of prosecutions. The email back to that is, I'm not sure how much grief we're going to get from gun walking. It may be more like people are finally going to say, we went after the people who sent guns down there. Now, lay aside the merits of that argument. How can you deny that people in Maine Justice knew gun walking was going on before that February 4th letter was sent to a member of Congress? That doesn't even get into the wiretap applications. That doesn't get to the factual predicate that a member of Maine Justice would have had to have read. All of this is before February 4th. That whole series of evidence predates Mr. White sending a letter to Congress denying the tactic. So my question to you is this: who participated in the drafting of the letter?
Well, first, this is going to be one of those rare instances. You're right. There was knowledge within the Justice Department of gun walking. It was related to wide receiver. And
Mr. Attorney, with respect, I don't like interrupting people, but with respect, several of these emails specifically mention Fast and Furious. I'm not talking about wide receiver. Love to have that conversation some other time. Well, these emails and memos specifically mention Fast and Furious.
They mention Fast and Furious, but do they mention gun walking in Fast
Yes,
and Furious?
they do.
No,
That's my point.
I'd like to see those. Those I would like to see.
We got them from you. So, I mean, we got them from Maine Justice.
Let's do this. I've promised to give you all some information. I would really like to see a memo that says gun walking and Fast and Furious. I'd like to see that one.
Well, if you're looking for a videotape confession, I probably can't give you that. But what I can give you is an email from 2 Maine Justice employees back and forth specifically mentioning Fast and Furious. It's a tricky case given the number of guns that have walked. I just find it stunning that you would want to avail yourself of the maximum departure from the guidelines that you can get for acceptance of responsibility and still sit here and not answer a single solitary question from a co-equal branch of government. Ms. Maloney asked a question that I thought was an extremely good question. Actually, she asked a bunch of really good questions, but I never heard an answer to this one. Is there a policy or procedure in place to investigate conflicts of interest between those who approve bonuses and those who receive bonuses? Not all at once.
The only requirement I know of, Congressman, is a financial disclosure requirement of all the senior officials.
So in theory, Mr. Brenner could be approving financial bonuses or other financial incentives for someone that he has a financial stake in whether or not they get more money. Is that within the realm of the possible? Because it certainly sounds like that's what went on.
Well, I'm not going to speculate on what's possible, but...
Why not?
Because I'm going to wait to read what the IG investigative report...
Well, if you're not going to speculate on what's possible, my next question is this. If Mr. Chaffetz or Jimmy Jordan told Chairman Issa that they weren't going to be here for a couple of weeks because they were CIA operatives, how would Mr. Issa go about verifying whether or not, and I'm going to be very clear, to date, neither Mr. Chaffetz nor Mr. Jordan have alleged that they're CIA operatives. But if that were to happen, how would Mr. Issa go about investigating whether or not that was true?
I can't answer that.
Well, the next person who claims it at your agency, how will you go about investigating whether it's true?
Under the current rules, as Mr. Sullivan pointed out, if there's an interagency relationship with that agency, the general counsel and the head of the agency would know.
So, what, a phone call?
I don't know what the problem
is. That what we're talking about, Mr. Sullivan? A phone call to verify whether or not someone really is a secret agent with the CIA?
Well, I testified earlier, sir, that in 2008, a new directive came out. I think it's Intelligence Directive 304, which requires the Director of National Intelligence to inform the head of an agency and the agency's general counsel if one of their employees is working undercover for the CIA.
Mr. Sullivan, I appreciate that. And it really doesn't matter whether you're a new Earth guy or an old Earth guy, but 2008 just seems a little late to be figuring out that with one phone call you can decide whether or not someone who's claiming to be a spy and traveling first class and racking up $900,000 in unwarranted compensation really does work for another agency. Look, I understand technology has progressed a lot. 2008 just seems a little late for us to figure that out. Ms. Tucker, more people have invoked their Fifth Amendment privilege against self-incrimination in this job than they did in my former job. And I was a prosecutor, so that's saying a lot. And two of them are current government employees. And just so there's no misunderstanding, they're invoking their Fifth Amendment privilege in connection with their official duties. We're not discussing bank robberies or narcotics trafficking. We're discussing their official duties, and they feel the need to invoke their Fifth Amendment privilege. So I want to ask you to do something for me, okay? Have you seen the text from Mr. Roseman?
Yesterday, when the committee released the report, yes, sir.
Okay, so you have seen these despicable homophobic slurs.
Yes, sir, I saw the information in the committee report.
Well, here's what I'm going to ask you to do. For me and, frankly, for our fellow citizens, before the close of business today, if you can, issue a statement on behalf of the IRS as to why he's still employed and still drawing a paycheck. If you've seen the text that I have seen, I would like an explanation as to how you can keep your job if you say things he said in your official
capacity. Can you do that? Can you explain to us how you can keep your job and your paycheck despite these homophobic slurs?
Sir, if I might, as I said in my opening statement, based on the information in the committee report yesterday, I am sickened.
All right.
Not only as
I appreciate that, Ms.
not
Tucker.
only as an IRS official, but
I really
also
do.
as a citizen.
I appreciate that. My question was actually a little more specific. Can you issue a statement by 5 o'clock today as to how someone who used this language in their official capacity as a government employee is still employed and drawing a paycheck? Can you explain that to us by close of business today?
Sir, if I might, we are having discussions at Internal Revenue Service.
How long do you anticipate those discussions are going to last? Because I just read the text this morning, and I've already reached my conclusion. So how long do you think it's going to take you all?
So we are having discussions with our general counsel.
How about close of business tomorrow?
So we're going to do our very best to follow due process, but candidly to also make sure we do this appropriately, because I think the committee's aware of the federal personnel rules. And we
If this doesn't violate them, Ms. Tucker, then we need to change them. If I understand your testimony, in part, the ambassador was interested in going to Benghazi because of interest that Secretary Clinton had in Benghazi. Is that fair?
That's fair.
All right. Now, Mr. Nordstrom, same thing to you. And if I'm unfair in my characterization, you need to correct me. I thought I understood your testimony to be that Secretary Clinton alone was able to approve facilities that were below specs.
That's correct. Part of the specs. There's two categories, SECA and OSPB. She is the only one that can authorize waivers for SECA. In this case, both apply because we didn't meet either.
So we are able to show that in part he went to Benghazi because of Secretary Clinton. In part, Benghazi was still open despite the fact it was below specs because of Secretary Clinton. And now to my third point, to complete the circle, who is Cheryl Mills?
Counselor and Chief of Staff to the Secretary.
And she was copied on that email, which demonstrably undercuts Susan Rice's talking points. And Cheryl Mills was copied on that email.
Mr. Gowdy, if I could add, Cheryl Mills was also the person that led our preparation for our October testimony. I'd never met her before, but that was explained to me who she was afterwards.
And apparently, she was also less than pleased with Mr. Chaffetz's visit to Libya, if I understood that testimony correctly, which I find stunning. He's a subcommittee chairman on oversight, one of the more decent human beings I've ever met. I've never known him to inspire that strong of emotion in anyone other than Ms. Mills. Let me say this to you, Ambassador, in conclusion. You have made a compelling case today for why it is important to tell other countries the truth. You made a compelling case that the decision not to tell the truth on Sunday morning talk shows adversely impacted our ability to get to Benghazi. You made a compelling case. All three of you have made a compelling case today on why it is important for government to tell the truth to its own citizens. So you made the case why we have to tell the truth to other countries, and you made the case on why you have to tell the truth to your own citizens. So if anyone wants to know what difference does it make, if anyone wants to ask what difference does it make, it always matters whether or not you can trust your government. And to the families, we're going to find out what happened in Benghazi, and I don't give a damn whose career is impacted. We're going to find out what happened. Mr. Morton, I will tell you from this vantage point, it does look like the decision to release detainees was a political determination and not a monetary determination. It appears to me that the release of detainees was part of a sequester campaign that included the fictional firing of teachers, the closing of the White House for student tours, the displacement of meat inspectors, and now we're going to release aggravated felons
some aggravated felons onto the street. Now, I've counted 6 times you have said you didn't want to rob Peter to pay Paul. I don't want Peter or Paul to rob one of our fellow citizens because you guessed wrong on who to release. So, of the level, what is a level 1 violator?
A level 1 offender, first, I obviously disagree with your characterization about these being political.
Well, that's fine. You can use your time to disagree with my characterization. Don't use mine. What is a level 1 violator?
With regard to level 1 offenders, they are aggravated felons.
And how many were released?
Congress. There are 4 presently.
How many were released?
8 were released. We have 4 presently released.
And what went wrong with the other 4?
What's that?
Why were there 8 released and only 4 currently?
So the 2 were released when the computer records were not correct, and we went back and we looked at them and we brought them back in. 1 was a mistake, and then
what kind of mistake?
Just where the instructions to the field were not carried out correctly.
All right. So if it's $122 a day to house 4 level 1 aggravated felons, then releasing them saves you what? About $600 a day?
Each day. That's right.
All right. You can't find $600 anywhere else in your budget?
We make determinations on a case-by-case basis.
Can
We've got to
you
make
find $600 somewhere else in your budget?
The question is whether that $600 is well spent on those people or someone else. And when it comes to somebody who's been a 44-year lawful permanent
I'm not talking about the 44. Was he a level 1?
I'm going to find $600.
Was he a level 1?
Something else.
Was he a level 1, Mr. Morton?
He is a level 1 offender.
He was one of the 4 that you released?
No, that he is released. That's right.
Okay. Mr. Morton, who made the decision to release detainees as part of your effort to comply with sequestration?
The determination was made by Mr. Meade, the Executive Associate Director for Enforcement and Removal Operations, in consultation with the Chief Financial Officer.
Who was John Sandwig?
Mr. Sandwig works for the Secretary.
Were there any conversations with him?
Not that I am aware of.
Were there any conversations with the Secretary?
Not that I'm aware of. I think the Secretary has noted that she was surprised and regretted the timing and the notification, and I agree with that.
If the release of aggravated felons does not rise to the level of something that the Secretary of the Department of Homeland Security should know about, what does rise to the level?
Listen, we release people every day, and the idea that we are going to review every single person that is released.
You release thousands of people every day?
We release thousands of people every month. We operate in a system. We had
407. But you don't blame it on sequestration, do you, Director Morton?
What's that?
You don't blame it on sequestration when you release the others. No. It's not part of this. It's not part of this strategy to get the public fired up that mayhem is upon us. That we're closing the White House for tours. That we're firing teachers in West Virginia. We're going to have to release level 1 aggravated felons because of sequestration.
First of all, that was never said. And the system allows for the release on supervision of people going through immigration proceedings. We are not detaining people for penal reasons solely for purposes of removal. And as I've said, the vast majority of people in proceedings by statutory design are not mandatory detention.
Who are level 2 violators, offenders?
They are either multiple misdemeanors or felons that Congress has defined as something other than.
And DUI would be a misdemeanor, right?
DUI would.
First offense? How about second offense?
Depends on state law, but most times.
Well, how about the states where you release people? Did you release any recidivist drunk drivers?
Yes.
How many?
I don't have the exact number, but we have released many individuals who had DUI offenses.
Repeat offender DUI?
Repeat offender DUIs. Most of them were single offenders, but some would be DUIs. I would note, for the record, Mr. Gowdy, Congress has not provided that a DUI is a ground of removal. In fact, most misdemeanors are not a ground of removal. It is the agency, by agency policy, that factors that in. I can't order you removed for having committed a DUI offense.
No, you can't,
That's not a
Director, but
ground
you
of removal.
certainly can request a programmatic rescheduling so you can move money around. And this notion that you don't want to rob Peter to pay Paul, you could have easily done that. You could have found $600 to keep these level 1 violators from being released, and don't act like you could not have.
Do you agree with me that the Constitution means the same thing whether there's a Republican in the White House or a Democrat in the White House?
I absolutely do.
Did you object when Harry Reid was having these pro forma sessions when President Bush was in the White House?
Nobody asked my opinion at that time.
Did you write any law review articles on it?
I'm sorry, no, I did not write any law
Did
review
you write
articles.
any columns in any trade magazines on it?
No.
So you only give your opinion when it's asked? You don't ever just decide, hey, this is wrong, I'm going to write a law review article or an op-ed piece and criticize the fact that the Senate is engaging in this travesty to thwart appointments?
I'm usually too busy practicing law to write op-ed pieces.
Well, we appreciate you taking time out of your busy practice of law to come today. What is your definition of a recess?
I would prefer not to opine on that. I'm a labor lawyer, not a constitutional scholar.
Well, ma'am, you can't have it both ways. You can't come and testify on a hearing about recess appointments and then decline to answer the seminal question, which is, what is a recess? If they were to take a nap, which happens from time to time in the U.S. Senate, is that a recess?
Well, my understanding was that I was asked not to testify about recess appointments, but to testify about the effect of the Noel Canning decision.
Who in the world asked you not to testify about something?
No, that I was not asked to testify about that, but that the topic of the hearing is the future of the NLRB, what Noel Canning versus NLRB means for workers, employees, and unions.
And that very case dealt with recess appointments, so you can understand why I would ask you, what's your definition of a recess?
I don't have one to offer at this time.
But you agree it should be the same thing whether there's a Republican in the White House or a Democrat in the White House?
Certainly.
And would you also agree that when the Senate passes something like the payroll tax extension, did anyone challenge that as being outside the normal course of Senate business, that they weren't legally constituted to pass that payroll tax extension?
I'm not aware of any challenges to that.
So how can you be in session for purposes of passing a bill but not in session for purposes of making a recess appointment?
I'll leave that to the constitutional scholars to argue.
Well, what's your opinion?
In my opinion, the appointments were proper.